I have a bunch of missed tests. Then on August 30th, I have the alcohol shows up. On September 13th, alcohol shows up, and we have more missed tests. So between, I guess, the 16th, the date of this report, and the date you went on the tether back in August, how many times have you drank?
6 or 7.
Yeah, you just are continuing to consume alcohol, and you're playing with the testing so that it appears as though it's just a missed test, when in fact, what it is you're drinking.
By Judge Simpson's courtroom, where defendant believes clever wordplay and a stack of excuses can somehow explain away a very clear drinking problem. He's trying to argue that multiple failed alcohol tests were just bad luck, poor timing, or somehow everyone else's responsibility, but his own the issue. Judge Simpson has seen this routine countless times. He's experienced, sharp, and not even close to buying the story being pitched. This isn't his first rodeo, and manipulation tends to stand out fast in a courtroom like this. Bond conditions aren't optional guidelines, and sobriety isn't something you get to treat as flexible. Asking for mercy carries a lot less weight when the rules were ignored from the start. As, oh, what do you think? Will the judge show leniency, or is this about to unfold exactly the way it should? Let's get into it.
And just state your name for the record, please.
Dustin Duncan.
All right. Your Honor, thank you for recalling this matter. So based on Mr. Duncan's appearance, I would ask the court to withdraw the bench warrant.
Well, you see the violation. The violation was the reason that I issued the warrant in this case.
Right, Your Honor. I've discussed the bond violation with Mr. Duncan. And Your Honor, to his credit, he did contact his community corrections agent and admitted.
When did he do that?
To consuming alcohol. The report indicates that he did, or it may have been the email actually that was sent out by Mr. Casey, where it indicated that Mr. Duncan did call him and admitted to drinking a twisted tea on September 13th, which is what ultimately led to the positive test on that date.
But
and then obviously we do have other issues. I'm aware of that, but at least he did admit to consuming alcohol to his community corrections agent. I can tell you that based on my discussion with Mr. Duncan, he has started attending some meetings with the Alano Club. He has reached out to Home of New Vision. He's an admitted alcoholic, Your Honor.
You wrote a picket?
I understand all of that, but my other problem is that given the other sort of missed test, I mean, what about you say the twisted tea on the 13th, what about on August 30th? What were you drinking then?
Same twisted tea, Your Honor. I've contacted Home and New Vision.
Well, I just said that, but you're welcome to say it if you'd like to.
No, I didn't. I contacted Mr. Leroy Pickett with Home and New Vision for a sponsor. I had 4 years clean and I relapsed. I know firsthand I need help with it.
Well, I understand all of that, sir, but so here's part of the problem that I'm having. Not only is there then these tests, he also has then missed tests, of which I would have to assume you're drinking.
Yes, I was.
So I'm going to ask you this, all right?
Okay.
I have a bunch of missed tests. But on August 30th, I have the alcohol shows up. On September 13th, alcohol shows up. And we have more missed tests. So between, I guess, the 16th, the date of this report, and the date you went on the tether back in August, how many times have you drank?
6 or 7. Maybe
Yeah.
8. I had 2 missed tests while I was in the hospital, but I did, yes, I did.
You just are continuing to consume alcohol. And you're playing with the testing so that it appears as though it's just a missed test, when in fact, what it is you're drinking. And you really, quite frankly, need to go inpatient. I mean, you know you can't do this on your own.
Correct, sir.
Mr. Bowling.
Your Honor, Mr. Duncan is the sole care provider for his 95-year-old mother. I don't necessarily disagree with what this court just stated, and I don't think Mr. Duncan does either. Would the court consider allowing him to be put onto a scram tether?
This defendant either truly believes he's the sharpest person in the courtroom, or he assumes Judge Simpson won't notice what's right in front of him. You don't repeatedly test positive for alcohol while claiming you don't drink. That's not coincidence. That's a pattern. And once you add in the missed test, the explanation starts unraveling even faster. Missing a test isn't a harmless oversight. Courts view a skip test the same as a failed one, because people usually avoid what they know won't go their way. Repeating the same hospital excuse doesn't make it more believable, especially when there's no consistent evidence to back it up. Someone who's genuinely sober doesn't panic over a routine test. What makes it worse is the attitude, the sense that he's still entitled to his freedom while ignoring the most basic bond conditions. Judges don't issue arrest warrants out of frustration. They do it when compliance clearly isn't happening. Bond is a privilege, not a guarantee. And in this case, it was treated like a casual suggestion if staying sober is the one requirement tied to your freedom, and you can't manage that. It's not bad luck. It's a serious issue. And the court doesn't have to pretend otherwise.
Pending getting into an inpatient treatment facility?
It's the reality is, in this type of circumstance, that doesn't help.
If nothing else, maybe it would be a reminder with a device on his leg that maybe he needs to call a sponsor if he feels like he needs to drink, or that he needs to attend an online AA meeting at any time of the day. Maybe the tether on his body would give a little bit more reminder than the SoberLink sitting on the nightstand table or the couch side table.
People have some concerns if you'd like to hear.
Yes, go on.
Well, the allegations include that Mr. Duncan was highly intoxicated at the time, walking into traffic, wielding a knife, trying to punch cars, making statements to incite a fight, continued that type of behavior when police arrived to take him into custody. My point in that is he was highly intoxicated during these felonies. So that's certainly a concern if he were to be released, even on a scram tether. At most, I would think the court could maybe consider a release to long-term inpatient treatment if you were to take him into custody. Thank you.
To adjourn the defendant's probable cause conference to September 30th, 2025, 9 a.m. And at this time, given the violations, defendant's bonded.
Should shock anyone who's been paying attention. You can't keep violating bond conditions, deny it, and still expect the court to offer leniency. The system only functions when its orders are respected, and this defendant showed he had no intention of complying. Judge Simpson didn't make this decision out of frustration. He made it because the situation left no real alternative. Jail isn't always about punishment. Sometimes it's the only way to put a stop to ongoing behavior. And despite popular belief, judges don't take pleasure in sending someone to custody. It happens when repeated opportunities have been ignored. This wasn't a debate about sympathy versus treatment. It was about responsibility finally catching up. If violations like this were brushed aside, bond conditions would lose all meaning. Where should the line be drawn between offering second chances and enabling misconduct? Share your thoughts below, and thanks for watching.